Hey everyone, welcome back to another episode of the Ask Amity Show. Today we want to talk about probate in California intestate succession rules. So first of all, what's probate? Probate is what happens when someone leaves assets without any kind of pre-planning. They don't have an estate plan, they don't have a trust. They may have a will, but that will still require you to go through probate and to probate those assets. So that's probate. It's a court process. It usually takes about a year to complete. It could take faster depending on really the assets, the amount of assets, number of heirs, how quickly things can get done with creditors, if there are any creditors or debts in the estate. But on average, from 9 months to a year. So it takes a while, and it can also cost a lot of money, because probate court requires you to pay court fees. And of course, there's attorney fees, which can be pretty substantial based on the size of the probate estate. So what is California laws of intestate succession? This is what happens when you don't have a will or a trust stating how you'd like your assets to be distributed, who you'd like your assets to go to. So each state, including California, has a list of kin so closely related to the decedent, the person who has passed, that they inherit from them by law for a lack of any other estate plan. The list invariably includes surviving spouses, your parents, your descendants, children, grandchildren, or great-grandchildren. Sometimes siblings and distant relatives may be involved as well, depending on who is still alive to receive those assets. So Jen's going to talk to us about some of the examples of intestate succession.
Right. So as Cindy said, if you do not have a will or any other document that directly specifies who your beneficiaries are, those wishes would not be followed, obviously. So if you forget to fund your new vacation home into your trust, then that home might go to the son that you've been estranged for years, if you're not married, simply because of your blood relation to him. So similarly, depending on who survives the decedent, the laws of intestacy would determine the order of who inherits your properties. So some examples are, if your spouse and your 2 children, for instance, survive you, then your spouse will inherit all of your community property, and then your spouse will inherit a third of your separate property, whereas the 2 children that survive will each take equally that 2/3 that's remaining. And then let's say you pass and you do not leave a surviving spouse, you don't have any children or any siblings, then the order of succession would be that everything would go to your parents. So it really depends on who survives you, who is going to be able to inherit your property, and the laws of intestacy will make that determination if you fail to make that decision on your own by creating a estate plan. So what are the steps, as a grantor or settlor, to make sure that you direct beneficiaries to your assets? We would recommend to make a point to sit down with your trust documents if you already have trust documents, or sit down with us to discuss, what you can do to make sure beneficiaries are listed on certain assets. We recommend that you kind of look over your estate and your assets maybe annually. Just sit down and take a look, make sure that everything that you've acquired during those 12 months, maybe if you already have a trust, is already funded into your trust. Make sure that if you have certain assets that can direct beneficiaries, make sure that's done. And if you don't have a trust, then obviously create one. Make sure that you list beneficiaries in your trust. Make sure all your properties are funded into the trust. If you want a particular beneficiary to receive that new asset in the event of your death, you can either add this provision in a trust agreement. Revocable living trusts can be changed at any point during your lifetime, as long as you have the capacity to do so. So make sure, once you create the trust, it's not a one and done deal. You can continue to review it, continue to make changes as necessary. Make sure all your properties are funded into the trust.
So if you'd like to learn more about intestate succession or probate, or anything that we discussed in today's video, don't hesitate to reach out to our team, our office. We'd be more than happy to speak with you. We provide free 20-minute consultation for new clients. Thank you for watching, and subscribe to our channel. See you in the next one.